everyone. Welcome back to another episode of the Divorce and Separation Coach podcast. This week, we're talking about the family courts and how they divide matrimonial assets. Two of the principles in England and Wales are around needs and fairness. And both of those are quite vague and subjective, which leads to a lot of confusion. Section 25 of the Matrimonial Causes Act of 1973 sets out the principles by which the courts create a fair and just outcome in a financial remedy case. But of course, there's a lot of discretion left to the judges, and those principles can be applied in very different ways from one courtroom to another. Some of the factors that are considered are things like each of the parties' financial resources, their childcare responsibilities, how long the marriage lasted. But one of the factors that's most important and that people usually get very concerned about is needs. And so how do the courts balance individual needs versus fairness in the divorce proceedings? Joanna Grandfield is a specialist financial and children lawyer who heads up Mills and Reeve's London family team. She's a trained barrister, but she's also a mediator and a collaborative lawyer. And her work involves advising clients with complex financial and children issues arising from family breakdown. Thank you, Joanna, for joining me today.
Thank you for having me.
A very meaty topic for you today. So I appreciate you joining me and agreeing to answer my questions. Could you start by just explaining, for those who don't know much about how assets get divided in family court, what Section 25 is and how exactly it lays out the principles for these arrangements?
Absolutely. It's a good question, Chloe. It's a big question, and it's something that we grapple with all of the time on a day-to-day basis. What the courts in England and Wales are trying to do is achieve a fair outcome. Mm-hmm. And what is a fair outcome for one couple will be different from what a fair outcome might be to another couple. And indeed, what a fair outcome looks like for, say, a husband may well not be what the wife considers to be fair, and vice versa. So what we then do is say we take a step back and say, okay, well, how do I decide what's fair? And what the Section 25 factors do that you talked about briefly earlier, what they do is set out some of the things to take into account, to consider, to decide what fair might look like. Yeah. So what you look at is the background to a relationship. So it's things like how old are the couple? How long have they been married? What was their standard of living like? Are there any children? What's their earning capacities like? Where have they lived? How have they lived? All those sorts of things. And you look at all of those things to come up with, it gives you sort of a picture in terms of what this family is, and what it has and what it might have in the future. Yeah. And then when you're looking at what's fair, you're then taking a step back and saying, okay, well, what are each of them going to need? Mm-hmm. And that's the most important consideration. Now, what a couple who have had a very significant income and have enjoyed very significant wealth, what they each need in terms of homes and incomes to meet their expenditure moving forward will be very different from what a couple with more modest means might have and have lived with and been used to. So that's one thing to bear in mind. Similarly, a couple where there are no children and have only been married for a couple of years, what each of those two might need moving forward and how they're going to meet those needs will be very different from what a couple who've been married for 30, 35 years, who've brought up four children, where a wife maybe gave up work to bring up those children, what they might need moving forwards. Yeah. So those facts, the Section 25 factors impact on what we think needs might look like, and therefore what might be fair in terms of how we meet those needs. Mm-hmm. What we then also look at is two-stage process, essentially. We look at the sort of computation exercise and then an allocation exercise. Mm-hmm. So the computation exercise is saying, okay, well, what is available for this family? Then what are we going to do with it, which is the allocation exercise. Yeah. So the starting point is to have all of the financial cards, if you like, on the table face up. So what's available? Are there properties? What is the value in those properties when you take off mortgages and all of those sorts of things? Are there any savings? Are there pensions? What are the income resources that people have? Mm-hmm. And when you've got all of those cards on the table face up, you then look at, well, how do you allocate them? Now, when you've looked at what people need, the starting point is that you say, okay, well, of those resources, what's marital, what's joint, what's been built up during the marriage, what should
Yeah.
properly be shared. You share those, and then you take a step back and go, okay, well, with the 50% or the half of those marital assets, can each of this couple meet their needs moving forward? Can they house themselves? Have they got a means to meet their outgoings on a daily basis for however long, for the rest of their lives, say?
Yeah.
If they have, that's the start and the end point. Fairness is achieved, we all move on. If there isn't enough there, then you look at two things. First of all, you look at if there's non-joint, non-marital assets
Yeah.
that haven't yet been shared. Do those need to come into the pot and start looking at sharing those? So to
Yeah.
provide each with some of those too. Or if there isn't enough, even when you've shared, say, everything that's potentially available, there
Yeah.
isn't enough to meet roof overheads and expenditure moving forwards, then you look at maintenance, and that's
Yeah.
making an ongoing payment from one person to the other to pay those bills. And when you're looking at that, it's for how long. And in terms of what's fair, then you're back in all of those circumstances of the case, those Section 25 factors. So things like, well, how long were this couple married?
Yeah.
What are their respective earning capacities? So if, for example, one spouse hasn't worked for some time, could they go back to work? Should they go back to work? And if they can, what realistically can they be looking at achieving in terms of an income on that basis? Similarly, if there is to be an income payment, how much should it be and for how long? The
Yeah.
days are now long gone. We're not looking anymore at when I started doing this job 25 years ago now. What we call joint lives maintenance orders were really quite common. So people
Yeah.
could expect to receive an income for the rest of their joint lives, unless there was a circumstantial change. Now that's much less common. Far more frequent is what we call a term order. So maintenance will be paid for a period of time,
Yeah.
and then we draw stumps, to use a cricketing analogy, and people then have to meet their own expenditure requirements from the resources that they are left with at that point.
Yeah. Yeah, so that's definitely been an evolution for sure. But it's interesting, that concept of needs and what it means, because people can interpret what you need in a very different way. I mean, technically, we don't need a lot of the wealth we live with on a day-to-day basis, but it really isn't about comparing what we need versus what other people have. It's what we need versus what we are used to. Is that it? It's really that need with respect to the previous lifestyle.
Absolutely. And that's not to say that people should expect to maintain that exact same standard of living and that same lifestyle, because that's something that's probably unrealistic for the vast majority of families.
Yeah.
But it has to bear some correlation. So because it costs more to run two households than it does
Yeah.
one, and there's only, just because a couple are getting divorced, their income doesn't double, but their expenditure could well do. So you've got to work out how to cut that cloth in a sense, in a different way. So and on a similar vein, I suppose, when we're looking at the sort of the individual circumstances of a case, of course, if there's a couple that have spent 25 years living in a £5 million property with a large garden, extensive grounds, and all of the accoutrements that go with that, well, it wouldn't necessarily be appropriate, and the housing needs wouldn't be met by moving into a 3-bedroom, far more modest house in a less wealthy area, and have that step down is too great. Whereas actually a couple that have lived maybe in a property that's worth, say, £1 million or £800,000 or whatever it might be, well, there potentially the step down wouldn't necessarily be as great as it would be for the other couple. So it really is about how a couple have lived during the marriage and what could be affordable as they move on from that. But you
And
have to
similarly,
inject an element of realism.
yes, and inevitably, I mean, you're dividing resources, so there's going to usually be some kind of downgrade in lifestyle, but there's that element as well of fairness, because I had just today a client was telling me that she was discussing with her spouse how to split their assets, and he was saying, well, most people live with £2,000 pounds a month, so why are you complaining? That'll be plenty. And yes, most people do, but she hasn't been historically, and they haven't as a family. But to add to that, there's the fairness element that he would have to live with £2,000 a month, if she agreed to that settlement. So how does fairness and the sharing principle come into place here?
Um, there is no entitlement to share in future earnings, if you like, because people that are, when the marital kind of partnership has come to an end, then it's come to an end. So
Yeah.
future earnings, future efforts, future endeavors, there's no entitlement to share in that. But
Yeah.
what judges do think is that it's fair, or I say judges, we lawyers, the family law system, consider it to be fair that if the other spouse cannot meet their reasonable needs referable to all of the contributions they have made during the marriage, not only in financial terms, but in terms of, for example, bringing up children, for example, supporting their spouse in their career, which might mean often, leaving their career. Why? Because their spouse has postings in different parts of the world, so they have to move homes every few years or whatever it might be. That if fairness then can dictate for them that they should be able to have a reasonable standard of living, reasonably proximate to what it was before, and therefore future earnings of their former spouse should be called upon to meet those needs, to ensure that sort of safety net and standard of living continues. But it's only if it's needed, and that's the point. So we consider it to be fair to be used if it's needed. It's not fair to be shared just because it's there.
And so fairness also often gets misinterpreted by people as being it's 50-50. It's fair because it's exactly equal, but it's not necessarily 50-50, is it?
No, it really isn't. And I think one of the things that I often say to my clients when I first meet them is, one thing I can pretty much guarantee is that you will come out of this, you won't come out of this process thinking that you got a fair outcome. What you will come out with is an outcome. You may or may not think it's fair. The important thing is that it's something that you think is a compromise or something that you're prepared to live with and can accept. But as you say, somebody might think that the fair outcome is 50-50. Somebody else might think actually it's more like 60-40. Somebody else might think actually you didn't do a jot in this relationship and you're entitled to nothing. Now, any of those scenarios may or may not be the right ones, and they may or may not be fair depending on who you're talking to. But don't think that you necessarily will think that the outcome is fair.
It feels like the right term should be more balanced. So it's about finding an agreement that is balanced in the sense that it's not necessarily split equally, but that it makes sense based on everybody's circumstances, and at the end of the day, everybody ends up with the same number of cards in their hand.
Yeah, absolutely. And I think, in a sense, knowledge is power in helping people to come to terms with what an outcome might look like. So very often, if you or you, we, because I know that you will do this as well, Chloe, when you talk the clients through the process and the approach that's taken here. So in terms of, there's the Section 25 factors, and these are why these different factors are important and will impact upon what an overall outcome might look like. This is why we think that the longer a marriage is likely to mean that an entitlement goes up towards that sort of more generous end of the spectrum. This is why when we're looking at earning capacities, if both have earning capacities, they're expected to use it, and therefore that might mean maintenance is less likely, or less likely for a shorter period, or more likely to be for a shorter period of time. All those things can help somebody to understand why the outcome that is arrived upon is considered to be fair by the legal system and the family law system here, but it won't necessarily be considered by them personally to be fair.
And so how do the courts deal with that sometimes conflictual definition? I mean, needs is not always the same as fair, when you're trying to meet each of the parties' needs, but also achieve a fair arrangement. How do the courts balance one against the other?
Well, as long as needs are met, then fairness will be part of that. If needs aren't met, then that's not a fair outcome. And then what needs look like, although it's obviously it's unique to each individual case. We can talk about ballparks. So judges will commonly come across, for example, in London, there will be divorces of couples that are in a certain part of London where children go to whether they're at state school or whether they're at private school. So there are those sorts of things that kind of, there are common themes, if you like. So what needs look like is also an elastic and evolving concept, I suppose. So a few years ago, I think it's probably fair to say that there was an expectation that that wherever possible, and we might bend over backwards to make sure that everybody can stay living in the same part of, say, London, for example, albeit in two homes, so that there's not too much of a difference in terms of for children going to school and all those sorts of things. I think we've moved on from there now, particularly because of house price pressures and so on. So, actually people can be expected to move up a tube line out of a zone, for example. So and that's now considered to be fair. And needs can still be considered to have been met by doing that. So I think there is an increasingly realistic approach, I suppose, in terms of actually it does cost more to run two households than one. And everybody is going to have to make some sacrifices, because the harsh reality of the situation is that that's what divorce means for most people.
Yeah. Well, you're dividing things inevitably. Yeah. And so in cases where there is much more wealth and, the assets exceed basically basic needs on both sides, how does the court deal with the surplus? Is that just divided equally, or is that still left for interpretation?
The interpretation bit there really comes down to what's matrimonial or can be considered a joint asset and what's not. If it's matrimonial, whether it's in single sole names or joint names, but if essentially it's been built up during the course of the marriage or treated as a joint asset or a jointly owned property and so on, that will be shared. So once needs are met, you decide what's matrimonial, what should be shared, and that is just divided equally. If there are assets that, for example, have never been part of that joint pot, often common examples might be an inheritance. Those are the sorts of things that tend to be, they're ignored, they're taken to one side, and whoever received that inheritance would keep it separately. So you share what's joint, what's matrimonial, anything else the owner keeps, as it were.
So to pick on your example of inheritance, then if the needs were not met without including that inheritance, then it might be brought back into the matrimonial pot.
Absolutely. Absolutely. It would be, it wouldn't necessarily be shared equally, but it would be a resource that would be taken into account in terms of dividing the overall pot to make sure that the needs are met.
Sense. So is there any recent case law or any recent cases that have come up where there's been evolution around how this is working, or are we finding ourselves in quite a stable environment in terms of how the courts consider needs and fairness?
I think that the real sort of developments at the moment are around how people are taking ownership more about their decisions in terms of what looks fair to us ultimately.
Yes.
Because there is so much store to be given and so much benefit, I should say, to people having ownership and coming up with an answer that they consider to be fair, that they can live with. Because if you can do that, that is worth, in my view, 100-fold an imposed upon decision.
Absolutely.
So there are different ways of doing that. What we have got is a big change in the courts, is an increasing push towards what we call non-court dispute resolution. So that's things like mediation or arbitration, which is like a private court process, private financial dispute resolution hearings, FDR. So that's the private sort of without prejudice, confidential, if you like, roundtable meetings where you try and sort it out with some help from an appointed sort of adjudicator who will give an indication as to what they think the right answer might be. So there's a real push towards that, sort of like just sit down and try and sort it out yourselves if you can. And if you don't try non-court dispute resolution and you do go to the court, then I think increasingly people are being expected to explain why that might be. And I think it's a matter of time before we start having costs, penalties applying to people that are just not choosing to do that. So that's one way that people can take ownership of that discretionary process and take ownership of fair and what fair looks like and what fairness means to them. The other way.
Sorry, I was going to ask, but do they truly get full ownership in that case, or they still need to get their agreements approved by the court, even if they've agreed among themselves?
They absolutely do, yes. But what you should have is there will be input from professional advisors as well. So, for example, if you're mediating a case, so for example, if I'm acting as a mediator on a case, I'm not giving advice to that couple, but I'm facilitating their discussions and trying as far as I can to make sure that they're staying within the sort of ballpark of the sorts of orders that would be approved by a court. So ultimately, once you've arrived at a decision, then you would then convert that into a court order, which then would be sent to the court for a judge to exercise their discretion in making sure that it's fair and then approve it. Now, the fact that you've agreed something will be given a huge amount of weight, and provided that it meets needs, housing, income, and in all the circumstances, those Section 25 factors, so the individual circumstances of that case still is considered to be fair by that judge. It's within the ballpark of the sorts of orders a judge might make exercising their discretion. Had they been asked to give an imposed upon decision, then they will approve it. Okay. And that's not to say that the answer that they're being asked to approve is the answer they would have given in a court process. But as long as it's an answer in the ballpark, that's fine. And I think it is a really powerful way of achieving something, getting to your fairness, as it were.
Yes. And that raises the big question of, how close to 50-50 do we need to be if we're negotiating these agreements? That's a question a lot of my clients ask me, is, is 60-40 okay, or is that not going to fly? There's no real rule of thumb on that, is there?
It depends on, it depends. There isn't, no, is the short answer. 60-40 might be fair in certain circumstances where, for example, there needs to be a shift because needs need to be met. Sometimes it might be because, for example, one partner has a very significant earning capacity, or such that they can rebuild that gap pretty quickly. And if you're not having any maintenance moving forward, such that the other partner is going to have to use their capital to meet their needs, that might be a reason to depart from a sort of 50-50 split. Obviously, you will be depart from 50-50 if needs require it. And similarly, it might be that you depart because although there are assets which we might consider to be matrimonial, so capable of being shared, if the couple think, well, actually, it wasn't really mine, that investment bond or something, well, actually, you got that because you brought it into our marriage a very long time ago, or it came from wherever it was. And so, although arguably it should be capable of being shared, we both feel as though it's something that we can properly put to one side. That might be a reason, for example. But that's the beauty of it, really. As long as you're in that ballpark, it's what does your fair look like? And then I think another real sort of development, which is increasingly gaining pace, I think, is agreements. So marital agreements, cohabitation agreements as well, but focusing on, given the topic of our conversation today, pre and post marital agreements. That's a way of defining your fairness, setting it out, and to the maximum extent possible, not 100% guarantee, but these days pretty much there. That can set out what you consider to be fair. And that can set out what you consider to be fair at the start of your marriage, which can be really helpful. Like, what sort of a family are we going to be? What's our married life going to look like? And in terms of, and you can build in review clauses. So you could provide, if you wanted to, well, if things change, if we have children, let's have a review after 5 years, let's have a review, or 10 years, or whatever you might want to do. There's pros and cons about whether or not to build in review clauses, but it's entirely up to a couple. Similarly, if there's a big change in the marriage, then that's when you might have a post-marital agreement. And commonly that's post-marital agreement is just like a pre-marital agreement. It's just that you enter into it whilst you're still married, but after you're married. And there, for example, if one of the couple was going to have a significant inheritance, say, or a business was going to be sold, or some big life-changing event was going to happen that caused everybody to say, well, let's just take stock and think about what we might want to do with this situation now. And again, that's a way of having your fairness weaved into the process.
So what I'm hearing is there are some rules and there are some principles that the courts apply, but there is still a lot of uncertainty around what a court might decide in X or Y case. And really the best way of maintaining control over the situation is to negotiate yourselves. There's a lot of sources of support to make that easier for those who struggle. But negotiating out of court is really the best way of maintaining some control over how things get split up.
Absolutely. And I think when we're talking about negotiating, that can mean lots of different things. So it can mean sort of round the kitchen table, two people sit, have a conversation, decide what they consider to be the right answer for their family. And that can be that, right the way through to couples who decide to negotiate, but they're not negotiating directly, for example. So they might have lawyers talking on their behalf, sometimes counsel as well. That can be in mediation, or it could be through an arbitration, so private court proceedings, if you like. And also having other voices and having other support there too. So that's people like you, Chloe, in terms of being a divorce coach to help them through that process as well. So there can be whole teams. They can have accountants there, wealth planners, all those sorts of people that are all sat around to help that negotiation. These discussions can be really quite complex and complicated, but that doesn't mean to say that they can't happen. You don't have to go off and have an imposed upon decision if you don't want to.
And I think it's interesting to understand that there's both ends of the spectrum are probably wrong. So it's not just applying 50-50, but it's also not completely Russian roulette. You can still maintain some control over how things go down.
There is, absolutely. And I think I don't know if this is the right thing to say as a divorce lawyer, or a family lawyer, I should say, but I'm a big believer in accept the things that you can't change. And the English family law system is the way that it is and has been for a very long time for a reason. And there are many faults with any family law system, and none is perfect. But what the English family law system does is enables account to be taken of each individual couple's unique circumstances, so as to arrive at an outcome that is tailored to what they need and what that family needs. And that, in many ways, has some real benefits, because at least what you can have is a decision that's right for that couple, as opposed to a sort of the computer says this because you've adopted a particular marital regime, or because there's some other way of dealing with it. So yes, it can be difficult, it can be challenging and hard to get your head around in terms of, well, this is so complicated, why isn't there a straightforward answer? What's this fairness look like? What are needs? What's sharing? This is all a riddle wrapped with an enigma. Or say, hang on a minute, this is here to enable us to achieve an outcome that works for this family. And if you work with the system rather than against it, then you will get to a better end result, in my view.
And that's always the objective, right? Is to find an outcome that works for that specific context. And that's why, again, negotiating those agreements is the best way, because you're the best person to know what's best for your family.
Exactly.
So it makes a lot of sense.
Yeah.
But in terms of kind of, I guess, that kind of starting point for people who are having those negotiations, especially those who are unsupported by professionals, I guess what you were saying earlier is you would start by just saying, let's look at 50-50 and see what that looks like in terms of our needs, and then deal with any surplus if there is any. Is that the right approach for them?
Yeah, I think it's looking at what's available, what's matrimonial. Let's go 50-50 on that. Take a step back and say, okay, what does that look like in terms of meeting our needs? Is that enough or not? And if it's not, then we look at, well, what else is available, or how are we going to cut this cake in a different way? Because there's only one cake.
That's the thing. Sometimes there is nothing else available to add to the pot, and it just means that everybody's going to take a hit, and there's no one's full needs are going to be met.
Yeah, absolutely.
It just depends on the resources available.
Yeah.
Brilliant. Well, thank you so much, Joanne. That was really interesting. It's a very complex topic, so I appreciate you helping us to kind of get a simplified view of it, and giving everybody all your tips and advice.
That's my pleasure. Thanks, Chloe.